so it looks like the first item on our agenda is the approval of the minutes from the December 15th meeting.
And I have no comments, but I can make a motion to approve regular agenda item 1.
Okay, and I'll second that. We have a motion and a second. All in favor, say aye.
Aye.
Okay, that passes. Item number 2 is the approval of the minutes from our January 11th BOE meeting. Any questions or concerns on that one?
I have none. I can make a motion on that.
Okay,
The
second.
same.
All in favor? Say aye.
Aye.
Aye. Okay. Item 3, approve Board of Equalization Assessor approved. Review the process date. I don't know if we did this in the last meeting because we combined with our commission. Is this similar to the minutes?
Yes.
Okay. Just the process report.
Yeah, the assessor approved it, so we're approving approval.
Okay. All right.
So I think those would be valuation changes, right, that have come through the assessor's office since the last meeting?
Sorry, which one?
Number 3.
3.
Process report.
Those are, yes, those are either recommendations that the assessor's office has agreed with what the appellant is asking, or we've had stipulations that have been signed.
Okay, perfect. Thank you for that explanation. Any discussion on that item?
I have none. I can make a motion to approve agenda number 3.
Okay, I'll second that motion. All in favor, say aye.
Aye.
Okay. And then approve Board of Equalization hearing process report. I think that's similar in that.
Yeah. A lot of little not little, but a lot of details on all 39 pages.
Yeah, I saw that yesterday. I was reviewing that. I didn't have anything.
I can make a motion
Content?
to approve
Okay.
item 4 then.
Okay, I'll second to that. All in favor, say aye.
Aye.
Aye. Okay, takes us to item 5. Approve or deny the reinstatement of the primary residential exemption on the parcels listed on the attached spreadsheet for tax year 2022.
I don't know. Jim Stevens would normally get up and walk us through this.
My apologies. This is officially my job, and I haven't given up any other responsibilities, so everything's crazy. These are applications to receive the primary residential exemption. They have returned the required documentation, and the assessor's office would recommend accepting these as on the list.
Okay, terrific. Any concerns there, Commissioner?
No, just a lot of pages, 139 pages to go through with this book. Thank you for that.
Oh, it's only getting worse.
I can motion to approve item number 5.
Okay, I'll second that, of course. And all in favor, say aye.
Aye.
Aye. Okay. Number 6 is approve or deny petition to Board of Equalization to hear appeal of property valuation after filing deadline for parcel 112960. Owner of record is listed as Gardner Plum, LC. Is that-
Thank you, Commissioner. I have not, I apologize, I'm not as prepared as I normally am. I did not pull these up and look at them before the meeting today. However, on this particular parcel, one thing that I would like to check to know, they stated that the address provided where the notice was going to was missing a 0 off of the address. And that caused basically the notice to fail to get to them. What I'm wondering right now, and that I'm going to look at, just if you just give me a moment, is whether or not that was on the deed, or if that was an error when we put the address into the system. Now, let me just verify that real quick, if you don't mind.
Yeah, he said it was sent to Suite 200 instead of Suite 2000 in Salt Lake City. It's a 24-story high building.
Yep, it's a big building.
Yeah.
Yeah, so the mailing address, we do have a correct mailing address now of 2000. But if I look back at the deed recorded, they said they purchased the property in 2021. I've got a warranty deed recorded in 2021. If I look at the document itself, the deed actually recorded in 2021 does list the suite number as 2000. So if there was an error in the address, I would probably say that was just a fat finger mistake when the information was put into our system. So that could be it's not really a failure to notify because the county really didn't make an error. We did send a notice to the address for record. We just made an error when we putting the address in there. So the auditor's office wouldn't have any problem with accepting this appeal late.
So with that, I'm ready to make a motion if that's appropriate. I can make a motion to approve the petition
Okay.
as stated.
Second to that. All in favor?
Aye.
Aye.
2-0.
Okay. Number 7, for Longman, Madeline Elizabeth, Sarah E. Longman. You have that one?
Okay, on this one, the petitioner is asking for consideration under unexpected and unanticipated and extraordinary circumstances. Basically, their reasoning is, I was a first-time homeowner, I didn't know what I was doing, please be nice to me. That's a very simplistic way of saying it, but essentially they're asking for the board to accept the petition after the filing deadline because being the first-time homeowner, they were not aware of options they have to dispute a property value. And apparently the purchase price of the home is significantly below what the county's established value is. And so, and they purchased it within the regular time frame that we would consider basically a valid area of data because we're looking at 2021 sales. They purchased it at the end of 2021. So it should definitely be in the right framework in terms of determining what the value should be. So it's up to the board. If this really falls into that, I would probably defer to the attorney's office. They agree or disagree or what their feelings are.
No, I mean, they bought the property in June. That is close to the time the valuation goes out. It's the board's discretion if you find that those meet the extraordinary and unanticipated circumstances.
Yeah, I would say it's not extraordinary or unanticipated. Just unaware process.
Yeah.
First-time home buyer, which for me, I tend to be more lenient when it's the first time. If it's multiple issues, then that's when we start to relook at whether we should approve these types of things.
Yeah. And they're being a new homeowner.
Okay. Yeah, I guess my only concern would be that, if that's the excuse, right? Like not that I'm not sympathetic, but being a first-time homeowner comes with a lot of different responsibilities, right?
Absolutely.
As it pertains to making sure the home is insured and making sure that my utilities are paid and things of that nature. So but this is my first one, so I'm kind of.
Let me verify one other thing for you if I can, here real quick. Sorry, this is appeal number 1394. If they did purchase, sorry, this is 13. Yeah. 1394. What I'm wondering, if they did purchase the property in June, really any property purchased this year would be any evidence. Yeah, they did purchase in June. So really what we're looking at is we're probably looking at a value that would actually be more significant towards next year's valuation because we're looking when the assessor's office and Clarissa was about to stand up and say the exact same thing. But when the assessor's office is looking at the value, they're looking at the prior year's market value. So when we establish values on January 1, we're looking at all the sales from the prior year. They purchased this home in June. All the valuation data was based off of 2021's data. And we did see a significant drop in market value, or a leveling off in many cases, in 2022. So, really, if the board was to deny the late petition, the appellant has the perfect evidence to appeal their value in 2023, if the value doesn't go down or come close to what they paid for the property. So.
Okay.
Also, if the board denies the petition, they can always appeal that denial to the state and let the state take a look at it if they really consider this a unanticipated or extraordinary circumstance. That statement is pretty broad. It does allow the board broad powers to accept a petition after the filing deadline, but
Yeah, I just want to be consistent, I guess, is my main thing. So I concur with,
And with that, I'll just make a motion that we approve at item number 7.
okay, I'll second to that. All in favor?
Aye.
Aye. Thank you. Okay, approve or deny. Petition to the board to hear appeal of property valuation after filing deadline for Mary June Hamblin. As Hamblin, Mary June Adams, excuse me.
again, this is based on the petitioner's statement that they, in 2021, accidentally signed up to receive their valuation by email. What I'm confused about in the statement is the process for signing up to receive your valuation by email can't be accidentally done. It has to be very purposely done. We both the tax notices and the valuation notices are sent out through our mass mailing vendor by the name of Masters Touch. They provide the e-notice website. It is a very purposeful process in order to sign up to receive a notice by email. A few years ago, the county was administering that process ourselves, but once we switched over to Masters Touch, we stopped sending those notices out ourselves. But that was in I believe that was in 2020 when we started with Masters Touch. So basically when COVID hit is when either that or 2019 was one of the first years we went with Masters Touch. So I question the statement that they accidentally and therefore missed the notice because it was going to their email. That's not really possible to have signed up for that accidentally. They would have had to have done that on purpose. Now, where she's a conservatorship, perhaps, I don't know what stage. I don't know if the mother is, signed up at some point, but it's not something you can do accidentally.
She's managing 10 parcels on behalf of her mother since 2016, so she's got experiences with this. She's ever been late in the past? According to this, she's not been.
Probably nobody check to verify that, but yeah, her statement is that she has not been late.
Yeah.
I have a few. Just on this parcel. This parcel's in an economic unit, which means it's combined with other parcels. And so any decision, if it's accepted or anything, we need to have the other parcels included with this.
So you're saying all 10 parcels are tied to?
Well, in the economic unit, I think I only have 2.
Now, she
This
seems to maybe claim that might be a mistake, and she seems unaware of why it's tied to the other unit. Are they owned separately?
Yeah, they're owned by the same person.
They're owned
They're
together?
next door to each other. One has the improvements on it. The other one has some additional land with it. And so typically we value those together. It kind of gives the owner a break. Sometimes it reduces it. This one, the parcel that she's talking about is hillside. And so if there is any, if we accept this and we make any type of adjustment to this, the other parcel is going to be affected because we've already made a hillside adjustment, which affects the whole property. And so we just want to make sure, I don't know if it'll be accepted or not, but
Right.
because we don't deal with that, but just want to make sure that we get the other parcel included in that.
And I appreciate the assessor's office bringing that forward. An economic unit means that they're assessing a group of parcels together, and it is not infrequent in an economic unit situation where a parcel like this is technically being overvalued because they're basically taking the value of the entire group and kind of spreading that whole value across all of them. It's not been uncommon in previous valuation years where we have a business appeal a single parcel, like say a parking lot, because the county has put a significant value on it, and they're arguing, oh well, this value is too much. Well, yeah, for that piece by itself on its own would be not worth that value, but as part of a larger business operation, and its value is just for the whole. So they equalize that value across all the parcels, and in some cases, it can even bring the value down of a more valuable unit and bring the values up of less valuable units. But basically, they're looking at it as if they were all tied together as a single parcel. So that makes perfect sense.
This property, is this a commercial property then, or is this a home?
This would be a commercial property, yes.
Okay, because I'm
Assisted-
looking
it's
at
an
the
assisted
explanation, and I,
Assisted living property.
just a living property, okay. And the other parcels, you say they're tied to this specific one, or is that
Yeah, so they're-
geographically
Yeah, they're
adjacent to each other?
together. And when they originally built the property, they were owned by or built the assisted living, they were used together to build that assisted living parcel or property. When they were sold in 2000, I believe it's 20 or 19, both parcels were sold together again. And I think what they want to do is try to separate those parcels.
But that would be a future event, not,
It could be if they come in and talk and we could look at things. The main problem is we have to look back and see if that additional land was required to be able to put that many units or that many people on that on that property. The original builders may have needed additional land to get so many units in that property. And I talked with Provo City, and they didn't have any information for me right now, but said that they could research it. So we don't have any information now.
So your real concern here is, I mean, without trying to get into the value of things, but that if this parcel were to be considered for an appeal, you would need the other parcel to come
Yes.
with it.
Exactly. That's our main concern.
Yeah.
Because
Because of the economic
we
unit.
could take this parcel down because it's on hillside, but that's taking all that value that was over on this other parcel. And so then we're gonna have to adjust this parcel and adjust it up to where we think it should have been. So yeah, so it affects, any type of adjustment on that one parcel will affect the whole unit.
This is kind of unusual. I don't know if we want to continue this and get the petitioner's consent to open up the valuation of both before we opened up the value,
Well, I think
before we go and grab it,
Right.
get their approval.
Well, I mean,
It's an
in terms of opening it up, I think if the board is inclined to open up, we definitely probably would want to look at that because they would have to appeal not just this parcel but a couple. But really, what is before the board today is to decide whether or not the petitioner's reason for missing the deadline falls within the statutory guidelines, and they marked extraordinary unanticipated circumstances. Like I said, I question the accidentalness of signing up for an emailed valuation notice or tax notice, because since I believe 2019 is the first year we went with master set. Since 2019, that e-notice process is is a registration process, not just a matter of checking a box and suddenly you'll start receiving statements by electronic like you do with a bank. I can understand why someone would make that assumption, but you have to take the notice, you have to take the code off of your paper notice, put it into the system, sign up, put in your email, verify your email. It's a several step process. It can't be done accidentally. So I would question their reason, their logic for missing the deadline if it's based solely on that.
Well, I'm inclined to deny this petition as my motion.
I would agree. Second.
Oops, sorry.
All in favor, say aye.
Aye.
Aye. Thank you. Okay, item 9. Approve or deny application for review by Board of Equalization of Farmland Assessment Act status for Robin and Kirkett. Robinson.
Good afternoon, board members. Ben Stanley with the Utah County Attorney's Office here on behalf of the Assessor's Office. And just by way of a little bit of quick background, especially for the benefit of you, Commissioner Gordon, as our newest member of this board, the next 4 items on your agenda are Greenbelt, Farmland Assessment Act appeals. And just to give a little bit of background about that process and how that works, the Assessor's Office has a statutory and a constitutional duty to make sure our tax system is fair. Under Section 2 of Article 13 of the Utah State Constitution, tax rates have to be equal, they have to be uniform, and so in essence, the assessor's responsibility is to make sure our tax system is fair. And so the Farmland Assessment Act lays out specific eligibility for a very preferential tax treatment in the Greenbelt statute. It requires things like there has to be 5 acres. And one of the things that we see is that there's often a case whereas people's home site on a 5.25 acre parcel grows and they add landscaping and they add perhaps a pool or a tennis court or other things, they sometimes encroach on that to the point where they don't have 5 acres any longer. They're no longer eligible. They also have to have things like an active devotion to agricultural production. They have to have a reasonable expectation of profit, which is demonstrated through documents. And they have to have a specific amount of production. And so we'll talk a lot in Greenbelt appeals about things like animal units per month or AUMs, which is a state mandated requirement to produce a certain amount to utilize the property sufficiently to be eligible for this preferential tax treatment. And I say all that to explain that the assessor's office has a responsibility to make sure that the system is fair and to make sure that people actually are eligible for Greenbelt before they're put on Greenbelt. We have a farmland assessment analyst here today with the county who is an expert in looking at these issues and can answer questions about specific properties. But in general, there's sometimes a temptation to be generous to a taxpayer in front of you. We're urging you to remember all the taxpayers who aren't in front of you, the ones that are saddled with a disproportionate tax burden. If a property owner that is not really a rancher, not really a farmer, or isn't really eligible because they don't meet the acreage requirement or one of those other 4 requirements I mentioned, that's what we urge you to do, is to think about everybody that's not here and to look at that closely. So this first one that you have is one that the acreage is not met, and you can see in the packet of information that the assessor's office has submitted that there are aerial photographs of the home site with measurements of the amount of space that has expanded into landscaping and other things. Again, there's a standard of practice that the Utah State Tax Commission looks at, 7.3, that says that the home site itself and property used in conjunction with the home site is excluded from the required 5 acres. And so if there's more than 0.25 acres of home site because landscaping has encroached into the farm area, then they're no longer eligible for farmland assessment. And so they don't get that preferential treatment. There may be other options for them like urban farming and some other tools that are available, but farmland assessment is not an option. And that is the assessor's position with this property that you see in appeal number 9. It does not have the acreage, and you can see the photograph measurements, and Diane is here and I am here if you have any questions.
And typically, this is not a public comment.
It's not
Public
typically
hearing.
public comment, although you often will hear from the applicant themselves, or you'll hear from the assessor in an introduction to the specific issue and why it was denied, and ask us any questions you have, and you could hear from the applicant if they're present. You don't typically take comment from the public, but you can turn those questions to Paul and see what he recommends.
Okay, perfect. Thanks, Ben.
My pleasure.
Yeah, just for your information, on all those previous items, the petitioners were not even notified of the meeting. But for these Greenbelt ones, they are notified.
Okay.
And often appear, and I would encourage you to hear from the applicant.
Okay.
In fact, we could ask if there's anyone here for this.
Is there
particular
anyone
piece.
here from the Robinson family? Robinson? Okay.
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 No, I do not have anyone else online except for Kerry McConnell, and I don't think he wants to speak to any of this.
Okay. Is that where the mic
Yeah,
is
Carrie
coming
causing
from?
that scratching
Carrie,
noise?
Carrie keeps.
No, he's not allowed to talk. I'm not letting him talk at all, so,
Okay, I just wanted to blame
I mean, I guess
him.
he'd be trying,
Is he
but,
muted on his end?
well, he's muted from my end, so he's not allowed to say anything at all.
Yeah.
So,
Well, I wanted to blame somebody for that
I
microphone.
mean, I guess if he
stuff.
wants to really say it, he could just walk across the hall and come and talk to us, but.
Yeah, perhaps. Okay.
The explanation on down here says change of ownership, but still part of a 700-acre ranch. Home was part of a ranch, which changed ownership. So does he see this 5.25 separate from this, or it's part of the 700-acre, the contiguous?
So basically what they did was it used to all be in one ownership, the ranch, and then they broke off that 5 1/4 into individual names to give them 5 1/4 acres, was it their son or whoever. Broke that off thinking, there you go, you know. But yet it's got cattle grazing all around, but just the home site takes up more than 1/4 of an acre. So they could go for urban farming. They could maybe re-record a document and gain more acreage and put it that name. I mean, they could do stuff in the future. It's just right now it doesn't meet the requirements.
We've been encouraging urban farming if they would like to do that, which requires an annual report, whether they're producing or not,
Okay.
as opposed to this 5-year process.
Yeah, the urban farming is a little bit of a different process. It's 1 to 5 acres, and it requires the annual review. It requires irrigated land. It requires a few slightly different requirements, but in many ways, it parallels the urban farming or the farmland assessment greenbelt standards. So the same kinds of production requirements and things like that.
Okay.
But Jeff, the applicant's not here on this one. It's the recommendation of the assessor's office that this application be denied because of this insufficient acreage to qualify.
So that, plus
Strictly
the
for-
explanation makes me think that he's not grasping the totality of this whole thing. So I'm happy to happy is the wrong word, but I can make a motion to deny agenda number 9.
I'll second that. All in favor, say aye.
Aye.
Aye. Okay. And now we're on to Gordo Prop LLC, item 10. No relation, by the way.
Yeah, but the next 3 are all related to each other. Number 10, 11, and 12.
Okay.
You'll see that 11 is also Gordo Prop, and 12 is Gordon Allen and Roxana D. These are all related properties, also Greenbelt, and just like I said with the last one, there's standards that the state requires that are in the Farmland Assessment Act that aren't met. In this case, it's production. These properties were turned into, I believe, a shooting range, and so historically they had sheep grazing in that area, and the sheep grazing was sufficient to reach the animal units per month to satisfy the production requirements under the state law and the tables that are promulgated by Utah State University. But with the installation of this shooting range and this different commercial activity, it no longer has that grazing. The ranchers in the area indicate that even if they had lease opportunities, because it's not fenced off, they wouldn't graze in that area. And so the lack of production is why the farmland assessment analyst for the county removed these from greenbelt status and believes that they are not eligible. And so these next 3, we can talk about individually or together, but our recommendation on all of them is to deny those as well.
This is the same properties that we discussed to start about 1.5 years ago, wasn't it?
It's in the same area. So, yeah, so Mr. Hyde is not the owner of the shooting range, but his property is in the same, it's all that same area. And it's all claiming the same production. And so that's why he kind of got lumped into that. So, but one of the parcels does still show ownership with that Gordo Prop and Paul Dallin, which is the owner of that shooting range. So that's kind of how he got linked.
And this is Mr. Hyde?
Yes.
Okay.
Am I able to come up to speak?
Yes, please.
Thank you. Thanks, Dan. Appreciate that.
We tried to have a conversation before.
I do know the guy, and let's see. I'll try to keep this really simple and it's not as complicated as it sounds. There is one parcel that I'll tell you the history on that. We just bought it a few months ago, but one of the parcels came up for sale, and Paul and I started to bid against each other. Paul is the guy that owns the shooting range, and then we started talking. It's like, well, wait a minute, I only want this part for farming, and he wants the hill. So I took the water rights and the 6 acres of ground that's good for grazing and whatever. And so they just haven't fixed that on the parcel map yet. And that's one of the reasons. There's one other parcel in question we just barely bought. I'm hoping, I was talking to Diane a little bit about this, until some of these things are resolved, there's just 2 issues left on things that haven't been fixed on the parcel map. All I'm looking for is a little bit of a delay in a decision on this. And if I may, let me just tell you my history. I could probably sum this up real fast. My wife and I bought 2 parcels, about 11 acres, just under 11 acres, a year and a half ago, and with the goal of making it our family farm. And there is an existing contract on it to graze sheep. That did not happen last year. Diane and I talked about this because I went out there and the grass kept growing and they didn't show up. And I don't know if it was partially because of the drought or some fencing concerns. Previously, the contract was that if we fenced it, then they wouldn't come out and graze on it. And so now I've since opened up a correspondence with one of the shepherds. Ironically, their last name is Shepherd. And they have about 500 sheep that they're going to be bringing out this year. They won't graze on my property. They won't be grazing on my property unless I can get several thousand feet of fence up, by spring, which fortunately I just retired. So I'm regardless of any decision, I'm going to be putting up the fence. I want the sheep on my property for a number of reasons. One, it desperately needs to be fertilized, and the grass growing high. There have been some fires out there, and the insects get bad. So even if I lose this, I'm going to have, if I can, 500 sheep on my property this year. One of the items is a road. There's a road leading from the lake up on the hillside, and one of the landowners is a little bit more hostile to anybody else having any activity up there. I was able to purchase the road. It's got 26 easements for all the property owners. It's worth very little. I actually, on the map it shows it's 4.5 acres. It includes the county road, the highway. I don't own the highway. There's another owner that does, and it just hasn't been separated on the parcel map again. So that was a mouthful. If I uncomplicate it, what I really would like, I am prepared, if you decline it, I am prepared to pay it today and just drive on. I'm hoping, though, that if we can delay this by this grazing season, at least halfway, July perhaps, whatever, that if I haven't met the requirement, that I just work with Diane and if I meet the requirement, great, approve it. If not, I'm happy to pay the rollback. The rollback's pretty severe, and I would mention I literally just bought 3 of these properties in the past 2 months. 2.5, one actually 3 months. It was October, November, and December I bought. But the rollback is property tax of 5 years. To me, that's a pretty severe penalty. It amounts to about $13,000 right now. So that's my incentive for being here. It's money I can put into the livestock fence. But this is going to be a long-term process. Either way, I suspect I'll be getting to know Diane pretty well because I'm a city slicker who doesn't know a lot about farming, and other than I come from a family of farmers, and I know I've done the math, and it's like, oh, this is pretty severe. So anyway, main point, two things we can't resolve because I don't want to pay rollback on land I don't own. And that's probably amounting to about $2,000 or $3,000, I think. It amounts to 6 acres, so Diane would know better. But I'm hoping that the 6 months delay would allow me one to have the title company get it fixed with you guys, and two, by then if we've actively got the 500 sheep grazing on there, then they've done me a favor. So that's what I'm looking for. Do you guys have any questions?
I didn't catch your first name.
It's Gordon Hyde.
Oh, so it's Gordon Hyde. Okay.
Yeah.
I see it now. Okay. Thanks, Gordon.
The Gordo prop, what that is I retired recently, and so I took my IRA money and I invested in a couple of additional parcels. So
Understood. Okay.
that's what that is.
Okay, perfect. Question probably for how common is it for the board to delay or extend a delay? Does that happen? Or
Well, let me explain a couple
common.
things about that. You have the ability to continue a matter always, but when it comes to the rollback tax, one of the reasons Greenbelt's tricky and why it's sometimes emotional is because it's a tremendous tax benefit that sometimes applies for hundreds of years. But when you are removed from Greenbelt, you are obligated to pay under the state framework a 5-year rollback. So you pay that difference of the preferential tax treatment for those last 5 years. So even if you had 100 years of Greenbelt tax, very small, you still pay 5 years of rollback when you're removed. And what the state law requires is it requires 2 years of eligibility, the preceding 2 years. And so from the perspective of the assessor's office, what would happen in a property like this is you would look at it and you would say, well, if it's not eligible and it wasn't eligible the last 2 years, there wasn't any grazing last year, then it's technically not eligible for Greenbelt. And so we would deny the application, but we could have the opportunity to go before you, same individuals as commissioners, to consider whether you want to abate some portion of the rollback in recognition of the fact that they're planning to get back on Greenbelt status or whatever factors. You have more discretion in that role as commissioners than you do as Board of Equalization members. So a continuation doesn't solve the problem from our view. A continuation, what we're looking at today is whether it was eligible the last 2 years. And if it met the eligibility requirements the last 2 years, then it should be considered for Greenbelt. And if it didn't, even if it gets eligible this year, it's technically not eligible for Greenbelt because it had to comply the last 2 years. And so we would say, our perspective is it ought to be denied, and then you could take it up, encourage the applicant to talk with Mr. Jones, who's an expert in some of the other processes that the county has, expert in most everything that we do, but can help kind of direct them through that process where you could look at it and say, do we want to abate some of this rollback because they are committed to getting right back onto Greenbelt status going forward. But we don't see a delay as the appropriate solution, and we don't typically see it as delayed in that sense.
May I bring up one item?
Sure.
I was just reading through the assessment, and it's
You need to come to the, here.
we have millions of viewers online, Gordon, and so you have to.
pardon me.
We'll have to break for a commercial pretty soon if that's the case.
I just want to say I'm okay working something out. In fact, and the reality is it did not meet Greenbelt last year, and there's can be a provision from what I read. I'm not an expert, I guess, but if something happened through no fault of my own, that it might be excused for that period. But we were not aware that it wasn't happening. There was an active contract for it to happen. They just didn't bring their sheep last year, and so I'm glad to work out anything. I know it's tricky with the 2 parcels that I don't. The one I don't own at all, and the other one I only own part of it. So somehow we got to work out something on that because I don't want to pay for that.
Yeah, you certainly wouldn't have any tax obligation for property you don't own, so that would that'd get sorted out, and
Okay.
we wouldn't ask you to pay that. If you didn't pay it, somebody else would be the one that would lose their property if there was any tax owed on it, so.
If you can, yeah, if you want to refer me to an expert and we could look at the assessment. Also, the road was assessed, I think, a little bit high, so we can talk about that. I only paid $13,000. It's a 56-foot wide dirt road that goes from the lake up to, it's like a half mile. So it's absolutely worthless other than driving to the parcels. And it's rated at the same evaluation as the other ones. And I would add, those are probably slightly undervalued, so maybe it's 6s, but.
It sounds like, so have,
Say here.
access has always been part of, reasonable access has always been part of the acreage that's been considered for agricultural use. It's when that we've had larger ground that was used for parking and whatever outside of grazing purposes or farming purposes, that was a concern. But is it 4.5 acres it's assessed as for this road?
I don't know if you have.
Yeah, it is. It is, and the part I bought was actually 2.5 acres, just give or take a little bit. The highway amounts to about 2 acres. It's still owned by another gentleman. They just made a mistake when it was recorded. It was supposed to be split out.
Okay.
Takes a while to fix.
Yeah, what the council was bringing up about whether we the same individuals operate in two different capacities. Here as a Board of Equalization and there as a county commission. There's a statute called 1347 that allows for abatements, portions or entirely, but it can be worked out separately. If it was denied here, it could be heard at the county commission and then adjusted at that point. But does that achieve what we're trying to do for this owner here?
I think that could get you there. I mean, it sounds like he intends to get on Greenbelt status in the future. He'll work with Diane closely on that. And so if he gets sheep there next year, he may have private claims against people that are in breach of their contracts or other remedies that don't involve the county. But in terms of getting on Greenbelt status, he can work with Diane and get on Greenbelt status going forward. This body, as county commissioners, in your other hats, other roles, could consider abating some portion of his rollback or looking at that. The way the law strictly operates, if you're not eligible the last 2 years, you pay a rollback tax. You got to be eligible for 2 years. You can get back on Greenbelt status and be on Greenbelt status going forward. And if you stay on Greenbelt status more than 5 years, it's a big, tremendous benefit to you in terms of tax obligation. But yeah, so our recommendation is deny these applications for purposes of the Board of Equalization, and then consider them if you want to apply and work through that process in another capacity.
So for this conversation from Mr. Gordon Hyde is item number 10 only, is that correct?
We're talking about 10, but we're actually talking a little bit about 10, 11, and 12. All three of these are various properties of his. There's this issue of the road that he can work with Diane and others to make sure that he's not paying on property he doesn't own. There are other parties that I assume didn't even appeal or didn't make an application to challenge that assessment. But the applicant who's actually challenged this has identified these parcels.
Right.
We think in every case there has not been production for the preceding 2 years. Certainly not both of the preceding 2 years, which is what the law requires.
Okay,
So
good.
from-
But
I
agenda
believe
number
2 years
11,
ago, though, they were grazing, so it was
Yeah.
last year I did not see any signs that they were grazing.
And
okay,
historically, it's been on Greenbelt and it's had grazing, but yeah, it has to be both of the last 2 years that it's been eligible to be eligible for this treatment. So that's why the assessor's analyst did it the way she did it. We believe it's the right approach. We would recommend that these be denied and that those other avenues be explored if desired by the parties.
So one issue here is that if everybody agrees that there was no production in 2022,
Right.
then the earliest Mr. Hyde could get onto Greenbelt would be 2025, and because he's got to establish 2 years, right? So he's got to establish 2023, 2024, and then he can get in for 2025, which is 2 years from now. So as a Board of Commissioners, normally we would say get back into Greenbelt, and then we can talk about a deferral or an abatement. So that kind of pushes it down the road a few years. That's sort of a hurdle here. That's an obstacle. So if he were to come and apply to the Board of Commissioners, my office property tax officer sitting over here, Adam Beck, he would likely say, to get a recommendation for a deferral and a future abatement, he'd probably like to see that Mr. Hyde has been granted Greenbelt, which wouldn't happen for 2 years. So there's that. Secondly, on this, if we're saying there was no production in 2022, there was a comment that it may have been from drought or didn't know what the reason was, and you weren't the owner at the time.
I was
Is
the
that-
owner of
oh, you were the owner?
2 parcels.
Oh, okay.
The one's under our personal name, so I can't claim any ignorance there, because
Yeah, oh, okay.
these other ones just came last minute, and boy, I bought right before the rollback, so
So,
it's a big surprise, yeah.
so if you have if you have a real desire to pursue the no fault of your own avenue to try to get that 2022 excused for no production, you may need to do some research or, kind of figure out why the sheep didn't come, or, I don't know.
I've got a pretty good idea. I think the Shepherd group just felt like things were getting a little too complicated because there's more owners. One of the owners out there, they were worried about trusting, what would happen with their sheep. And so this is what I'm finding out just literally this week. And so, it was a surprise to us. I want them there. I need them there. And even if I'm paying the regular taxes on it, it's fine too. I need them for long term. Hoping long term we turn it into a nice family farm that's productive, and can't build yet, so that's a little tricky.
For my understanding, if he were to put sheep on it in December, does that qualify for 2023? How long do I have to have the grazing take place?
They won't be there. They won't be there this year.
Okay.
It's covered in snow.
You mean-
And I
you
wouldn't
mean-
have it fenced by
But in
then.
2023,
2023, yeah.
sure. So this year, like for my understanding, like if that time frame, does that make sense? My question,
Yeah,
like if
and it's a tricky one. It's not a simple answer because it depends on those animal units per month. So there's a certain amount. So it depends on the number of sheep. It depends on how many acres. It depends on how those acres are designated. And so if they're designated different kinds of quality of land, they're expected to be more productive than other kinds. And so it's a calculus based on a lot of factors.
Okay.
And if they meet enough, if they have sufficient animal units per month, it could all be in the month of December. But it has to be a sufficient amount to qualify it for the year, and that's a mathematical formula.
understood.
I think we'll have them on there regardless this spring. So as long as I can get the fence up, so.
The shepherds may, I know when they brought graze, those sheep farmers that would come to our farm, they brought their own electric fence. And so I don't know if the shepherds have that opportunity.
They did.
Okay.
And talking about the land quality, some of it's okay. The topsoil's probably only about a foot, and underneath that, it's all rock.
So
So
putting those stakes in.
normally they're pretty mobile, and they brought their electric fence with them. But it's not, in this case, getting those T-posts in there, they get down about a foot, and so it's not a mobile thing. You need to have it set up permanently.
Gotcha.
And that's what I'm going to be doing regardless this spring.
Now that you're retired.
Yeah, I'm looking forward to it either way. So.
Good. Okay. Well, I appreciate your willingness to work with staff. I appreciate your time, Diane, and, working with Gordon. So
Well, okay, thank you.
Thanks.
So if we were to deny this, he could work with council to see whether to bring it back to the commission to abate some of this, given the intent of what he's attempting to do, correct? Under 1347.
You can always apply, and we'll work it through and
Okay.
put it before the commissioners.
And we're supposed to treat everyone the same, given exceptions as they come, because there are so many variations with each property owner, with each individual. So I'm inclined to go ahead and deny these and then allow him to be able to come back to the commission if he chooses to do that after working with Paul Jones here.
Do we need separate motions for each item? Or can he say items 10, 11, and 12?
Yeah.
Okay, is that what I'm hearing? Okay, I'll second that motion. All in favor? Aye.
So that's 10, 11, and 12
10,
is
11,
denied.
12. Okay,
Okay.
okay. And seeing no other action, I would entertain a motion to adjourn.
I can second that motion. We are adjourned. Or use, that's your role.
All in
You're supposed to
favor? Say aye.
Aye.
Aye. Thank you, everyone.